comments. Okay. Hopefully people will come back and see me. What a shit show. What a shit show. Let's see if this works. Bloody hell, I need my coffee. If you're here and you can hear me, please say, gotcha. Yay! Yay! Back to StreamYard. Okay, let me add this. So I'm going back because I haven't seen a single thing, people. I haven't seen. Why is there pool already going? What's going on? Okay. First off, hello, Armand. Hello, Crisby. How are you? Nice to see you. Hello, Raven. Hello, Dawn. Long time no see. Oh, so as per usual, I have not seen a single. I am live. It says I'm live. Yep. Says I am. Hello, music by Brian. Yeah, so StreamYard is very bloody expensive. So I decided I wasn't going to use StreamYard anymore. And I'm trying to learn OBS. And obviously, you've seen I had a mic issue and a sound issue. So here I am on StreamYard. So did you all watch today? Or do I have people with me that have not seen it? Well, I hope the Donald trial wasn't as much of a shit show as me coming on live. You and me here, we got each other. I haven't seen a single thing. I do know that Luis, or not Luis, sorry, Leah sent me a text today saying, OMG, can't wait to hear your take on today, the shit show of all shit shows. Hope you're having a good day. It was a disaster for the defense. Okay. Well, let's get started. Let's just get started. I'm excited to hear this.
You're not accusing the state attorney's office of doing anything. Merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in Sheriff Google, however, at this point in time, it's not going to go to court to need to go through it category. The witnesses that you're referring to have been disclosed to the
Mine, not by us, because again, we have not had a chance to speak with them.
Do you intend to call them witnesses?
If we can confirm the information,
Doesn't, you're not answering. If you're not actively intending to call a witness, you're not going to seriously disclose it. At this point, I do not have to engage in advocacy hearing on this matter. As far as witnesses that you may be investigating or you may speculate, the testimony. Until you disclose it, until they actually intend to call it, there's really not much I can do with it. If you wish to hear and want to share, will.
Quick question, guys. Are you hearing that okay? Because it seems like the sound's coming. You guys are only getting the sound through my mic. I can't even tonight. I can't even. Hello, glass half full. Welcome back. It's very low and muffled. What is going on? Yeah, it seems like, oh my goodness. See, when you mess with something, it just goes off the chart. Because I'm noticing that my mic is catching the volume, which it never did. Okay, hold on. Let me go. We'll just quickly go in here and go to audio and see what. Let's see if that works better. Okay, I'm going to try it again really quickly, see if that works better.
But as far as protecting the subpoena and speaking to these people who are either not under subpoena or not witnesses, not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for court's assistance because the rules.
To do what exactly?
So that we can at least.
Okay, so I'm very clear talking, but the sound coming from the audio is obviously not very clear. So, okay, so they're not coming through my speakers. Okay, now let's try this again. I can't believe I'm having this issue.
Speak with her to find out if she has anything that's missing.
The court has jurisdictional authority limits. For someone who is not under subpoena, I just can't compel them to come here or go there, do certain things. There is no subpoena for these individuals. If they choose not to speak with you, so be it. Bring the undersheriff, speak to these matters that we raised.
How did Judge Everett sound there? Not great. I have no bloody idea. Everything just seems to be. Let's just try this. We'll try it again. Muffled. This is weird. Was he muffled last night too?
Thank you. Okay. Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the time limit.
So, John, I've always been on StreamYard. Always been on StreamYard. I'd link to YouTube. I've never ever had this problem with any of the stuff. But I noticed that StreamYard was acting up. It wanted me to update it. So I thought, oh, I'll just jump over. This is where I'll make my switch. Let me just see here. Because sometimes it's just ridiculous. Yeah, John, it's completely clear on my end. Completely clear. That's like the other day when you guys were saying that it was you couldn't see it, but you could hear the volume. I was like, I can see everything perfectly fine on my end. I guess it's just the StreamYard does not want me to be doing this. Like there's not much more I can change on my audio. It's weird. Because I never had this problem before. Like I'm testing the speakers and everything is working. Once I almost bought a new cell phone because somehow I had got on an airplane mode. I have no bloody idea what the hell is going on. My voice, yeah, see, the voice is very clear. My son did something to it. I don't know. When he was helping me with OBS. And now I've been having this issue ever since. So something he's changed has to have done this. Voice is very clear, but the court case isn't. So I don't know. What if I do this? What if I just put the speaker very close to the microphone? Okay, hold on. Let's see if this works.
Itself, in fact, is occurring in the middle of the trial. That part of it, again, these are certain things I cannot assist with. Sheriff Google, please raise your right hand. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir.
If you can just stand in front of the court before instead of taking the witness.
Okay, so that don't make no difference. So Well, guys, I hate to say this, but I am computer illiterate. I'm not, I am absolutely not any good with computers. When I go into sound on the computer, oh, hold on. I think I just might have figured it out and I might be a genius on computers. I might just be a genius. Let's try this.
If you can explain to me what occurred with one question, deputies that
How's that, guys?
may or may not
Wait, yeah, see, but that's the volume of their thing. Okay, hold on. There might be something else. No, the sound's coming from the computer. Me is coming through the mic, but the sound from the court is coming through the computer. And I have never, ever had this issue before. I do not know at all what the heck. Let's do this. That's the microphone. Yeah, I figured that's what it was sounding like. That it was just coming from my mic, but I can hear it coming from my speakers. Can you blow up your sound settings? I'm going to share my screen so you guys can see what I'm doing here. I'm going to share it. Since this is where we are right now. This is what it's come to. So I'm in the computer settings right now. So that's my speakers that are hooked up through the microphone or from the headphone jack on the thing. That's my microphone. Let's turn everything to default. I don't know what he changed, so oh, you know what? I bet you that's what he changed. Because he set it up with Google Chrome and I'm running, no, that's through Google Chrome. I'm running my YouTube through Google Chrome. So that's not it. What browser are you using to stream the court feed from? Google Chrome. And everything is way up. Maybe if I shut this Microsoft Edge stuff off. Try reset. Oh, where's that? Hold on. Is there a reset button? Oh, right here. Reset sound devices and volumes for all apps recommended default. Let's do it. Okay, reset. Let's try. Let's give it a go. Why, shall we? Of course we shall. Why not? Because this is what everybody wants to be doing right now is, figuring out why there's no volume.
Actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so chose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dick, and she relayed that information to Deputy Franklin.
Did you or any other person in the position of authority of this guard instruct them not to speak to the?
No, sir.
Okay, you know what I'm going to do? I'm going to pull these damn speakers out. And let's go from there. Okay, let's try this volume now.
It is our understanding that Officer Franklin is now on leave, not available to be served.
That's not my knowledge.
So she is available to be served.
Okay, so can you still hear me too? So we got volume.
Share Google, there's no inquiry on the negative sign this topic. Appreciate you.
Okay, so John, you said you can hear the courtroom. Glass half full says can hear you fine. Court is still low for me anyways. My crazy. Okay, my crazy Nan says can hear you. Great, thanks. Okay, I'm giving it. It's muffled. I have no idea. It must be. I'm gonna try a different feed because I cannot understand. I've changed everything on my end.
Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that information. after discussions amongst Ms. Fulford and I,
Like, I've got everything maxed.
given the status of that individual and the misinformation.
Right, as to the, I always say, what it is, this person wanting to be disclosed about all of this part.
There,
That's the dog. If you need to follow up with a subpoena for this individual, chosen not to speak with you, do so without haste. The jurors at time of selection were told this to be 3 weeks, that could possibly be longer, but 3 weeks is what they were told. 4 days, but I'm assuming that's going to be that.
I apologize for not having a chance to prepare a list. At least for this morning, our intent is to call Chris Adams, Linda Bailey, Sarah Newhouse, and Marisol Descalzo. This afternoon is up in the air, and that's going to require some additional conversation.
Okay. I'm going to take it to a witness and see if. Well, wait, that's Wendy's witness. That's Wendy's lawyer. Hold on. Tell me if it sounds louder that they're actually in the microphone.
Chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow of the International Academy of Family?
Approximately.
Okay, guys, tell me if it's still muffled. If it is, I'm gonna call it quits till I figure out what the heck is going on with my audio. I've never had this issue before, and I'm not gonna make you guys sit around and listen to something you've already listened to. You know what? Hold on. Let's try something else and see if it's just the court. Oh, I don't want to do that. I'll just do this for a second. I just want to see if it's just the court. Can you hear that better? Okay. No, something happened when my son was helping me set up OBS. I think something happened and I am not clever enough to figure it out. So, of course this happens during Donna's trial, right? Of course. But if that's not working, like I said, I have absolutely no, so it's not better. I'm not going to make you guys sit around with me and watch something when you can't hardly hear it. So I'm going to have to watch it alone. And then I'll have to write down everything that I hear and find, and we'll have to talk about it as soon as I get this fixed. It's weird, though. All those shows I've always done and never had issues till now. Never had an issue. Oh, we might as well stop sharing that because that's useless right now. It's unstable for you now. Yeah, something's not right. I noticed last night because if I'm not speaking, then you obviously don't see anything around the coffee cup. Well, I wasn't speaking, but I was still seeing the microphone being activated. Armand says it was fine for me when you had it plugged into your speakers. I'm not too sure what the heck is going on. Watch, I'll be up till like 3 a.m. trying to figure this out. John Smith said muffled as well. I don't get it. Yeah, I sound clear. That's great. But I gotta get it so you guys can hear this.
Drafting of pleadings. I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you?
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendy Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendy, I don't remember that Wendy had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness?
I just put it through my speakers, guys. Or through I got the speaker up to my microphone. I have no idea what went wrong. But I bet you can't hear me very well now.
The motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 20.
Okay, let me just say this. Why the hell is Wendy's divorce lawyer the one that lied about money and all that? She's a witness?
The hearing would have gone forward.
Correct.
the judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment. We'll retain her, but she's free to go about her business.
Thank you.
You may step down. Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. The jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room. Resume at 10:05. Good morning.
Wow, court's on a short break already? Holy Moses.
You can be seated. Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
I skipped ahead. Okay. I'm sure I did. That was I'm just going to keep doing this so then we get... That was Wendy's divorce lawyer. She's witness for the defense. That's wonderful. But I will say something. I'm going to point something out. Okay, so that lady that was just talking to Fulfer, I thought I saw her in the courtroom. I'm just going to scan back because I swear I saw a blonde in a blue suit in the courtroom. Oh, well, if when I got to see that. I'm sorry, but I got to see that.
And I've had a few suicides, but it's rare. And
How did we skip so far ahead?
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
No,
Correct.
okay. Hold on.
that's happened before.
Armand says, I understand Georgia got mad with Wendy's divorce lawyer. Sarah Dugan's doing the cross. Watch how Jackie has her head down most of the day. Is she stoned or what? Oh, she's always fucking stoned. Oh, the next witness is much longer and has a fiery cross. But first you have to watch the judge yell at defense get yelled at by the judge. Okay. I'll go back to Wendy's lawyer. Judge Everett yells at the defense again. Oh, I'm here for this. I am here for this. Oh, red and right. Georgia slices and dices the next witness. It was a thing of beauty. I can't wait. Oh, the next one was Wendy's lawyer too. Of course. Okay. Okay. somehow, some way, we will get it so we can all hear it. And I promise I will get this fixed.
When we advised Ms. Bailey of this information.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot.
Oh no, oh no, oh no, oh no. Tell me they allowed another witness to sit in the courtroom. Is this what I'm hearing? I'm hearing that they did it again? Jesus Christ. I'm sorry, Rashbaum. I'm so sorry. Oh. This is what, 2 days in a row? Oh my God. I'm sorry, Everett, but Rashbaum, I'm sorry, man. You're a fucking genius compared to these two. Oh.
Completely recall at this moment, but we'll review. At a minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it
I would like them to stop violating the rules of sequestration. Oh, George is pissed. Look how red her face is. Oh, I'm here for this. Oh my God. Oh, hey, fancy man, where's your tie today? Oh, hello, Sue. Hello, Sue. How come you didn't testify yesterday for your good friend? Oh my God, I am so here for this.
related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know. I'm going to go to the court reporter's office to check the sidebar. From there, we will finish this matter and resume testimony.
Okay. Oh, so much to say. So much to say. Zellner, you fucking little prick. Yes, I called you a prick. This is your hometown, buddy. This is your hometown. You most likely will have other cases in front of Judge Everett. We expect this from Pill Pop and Jackie. But does Rashbaum have a spot in the canoe for you when you're done this case, Zellner? Because you've done nothing but prick moves the whole time. You're not ready for your case. You're constantly flipping papers. That's right, not their first dirty trick, no. This blows my mind that this lawyer lives in this town. No, this was their second. I think it's their second. He lives in Tallahassee. He works. His practice is there. Look at the smug face. Look at, he's happy. He's smiling. Oh my God. I can't. Like, Donna's probably thinking, okay, I should have kept Rashbaum. You kind of should have now. Oh my God. This, guys, it just started. What is the rest of the day gonna be like? Oh, it was 3 violations? I thought he just said 2. What is the rest of the day gonna be like if this is the first thing that happened right after their first witness? Oh, come on, Everett, come back and just give them the 1-2. I don't want to miss a second of Everett. So we'll just... Oh boy. Yeah, Don, you're right. He knows what he's doing. He's gonna... Oh my God. Like, okay. I understand defense attorneys need to play fast and loose with facts. I get it. They have to. But you can't be breaking rules. Oh my God. Their day hadn't even started. Please tell me Donna testifies. That would make this all worth it. John, I was thinking the same thing. A mistrial or giving her a reason for an appeal. Like, what is with her? She must have a magic hoo-ha too. Yeah, breaking rules, cough, cough. No, I don't really want to know if she has a magic hoo-ha. Oh, Jesus, Everett scared the shit out of me.
Presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Yes, sir.
Please make your arguments.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies, and then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
as to both the context and the discussion that's concerned an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify, Mr. Zellman?
Judge, the prior
Why should this witness be allowed to testify, Mr. Zellman? He is pissed. He's pissed. Everett's pissed, and I am here for it.
page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week when during the sidebar.
Ms. Kaplan, what are you asking for?
Sit down, Zellman.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But you did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Reviewing Earhart, exclusion of the witness. The court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
She's still in the courtroom. She's still in the courtroom. Why was she not told to go wait out in the hall? What the hell is wrong with these people? She's still in the courtroom. Hey, Steinbeck, can you pea shoot at this Rick son of a bitch here? Lying piece of crap.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Crawford can be taken on this matter. After that, I will step down, briefly review what I need and make a ruling. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc. in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm what I supposed were facts. And
Wait, hold on a second. Did fucking Humpty Dumpty here, Prick McPrickster, did he just say that she was brought on as a defense witness? So if she's brought on a defense witness, then she's getting paid. She's getting paid. So all these lawyers in Tallahassee that want to get on the Adelson gravy train, all they got to do is become an expert witness for Donna's trial to get paid? She's getting paid. The other lawyer that was just on was getting paid. Zellman's getting paid. Pill Popper Jackie's getting paid. How many more lawyers are going to be expert witnesses in the Donna Adelson trial? Next, we're going to see TJ up there. He might as well to get paid too. Listen, I'm all for it. Hey, TJ, tell me you'll be an expert witness. You're going to get paid. The Adelsons are just showering everybody with money. Oh God. I think she's a family lawyer. I think that's what I heard, Armand. Oh my God. I couldn't believe it. I just like, wait, he said She was brought on as an expert witness. That means she's being paid. She's billing Donna Adelson by the hour. Oh, Jesus, that's brilliant.
I've known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donald Adelson and Wendy Adelson. There were
I want to see those Donald Adelson and Wendy Adelson text messages. Has anybody seen the Donald Adelson and Wendy Adelson text messages? Huh. I kind of like this. I'm going to freeze frame this picture. I may use the lying bitch on my next thing. I should put all the lying lawyers of Tallahassee on my next thumbnail. Oh.
a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendy Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendy as well.
And in preparing for trial, in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Miss Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Miss Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Job well done. An examination.
Are you
purpose
kidding
of
me
proffer.
right now? Hold up. Hold the hell up. Are you kidding me? You asked her what she reviewed, all of that. She had to sit in the courtroom for what reason, Zellman? My God, that's all you asked. How much was that worth? I'll be a expert witness for Donna. How much was that worth? I can't promise it's going to turn out good for her, but I'll still sign up. Yeah, Armand, she was in the courtroom too.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously? In your
Oh, this is the
preparation?
proffer.
I think so.
Okay. No, Your Honor.
No,
Please step down.
no, I don't think so. Oh, this was just the proffer. This wasn't the testimony. I was like, what the hell is going on here?
Ms. Bailey.
return in a few minutes.
Georgia looks good today. Right, John? I'll do it. I can't promise that it's going to work in Donna's benefit, but none of her other witnesses are. He looks pissed, yeah. Who do I think will do the closing? I think for the state, it's going to be Georgia because Sarah did the opening. I think for the defense, I think it's going to be Jackie because she likes to be in control. She's a Donna wannabe. Oh, you don't like the outfit? I like the olive colors, so. Oh my God. Is Judge Everett gonna say she can't sit? The gold belt, yeah, I agree, no gold belt. Yep. And these are Tallahassee lawyers. This, if it was Rashbaum, okay? If it was Rashbaum that did this, it's still bad. We would have mocked it. We would have had fun with it. But Judge Everett would have been this nitwit. Tiny little nitwit man is never going to be in my courthouse again. These two could possibly have another case in front of Judge Everett. I hate to be their next friggin' defendant because Everett's going to get back at them for this. Okay, what are you going to say, Judge Everett?
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 4-1-2-7-2-332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who was subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
Oh, he
As long as the instruction that the court is going to give, the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand.
Oh, he ruled in favor of the defense there. Wow, you can tell he's mad. Wow.
If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems.
Holy hell. He had no choice was the way I interpret it. Yeah, wow. Twice they made a mockery of his court. He doesn't want to give Donna something that might be reversible on appeal. Yeah, but I don't see how that could be reversible. It was 2 violations done by her lawyers. It's a mixed ruling. He doesn't want to open it up for appeal by excluding her, but he's going to give an instruction that the jury can find her sitting in, can go to her credibility. Yep. I agree. Wow. That time the judge admonished Donna, Jackie had her head down, hair over her face the entire time. Donna, you're on your own here. Yep. You're about to hear the most annoying and pompous witness ever. Jesus. It's really disgusting. Oh, here we go. It's okay, Rochelle. Georgia will. Okay. Look at this. Look. Oh, I'm ready for my close-up, Mr. DeVille. Frig's sakes, what's wrong with these people?
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may
She's a lawyer. Does she know she has to be stand up to be sworn in?
examine as you're ready.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick that details all of your child practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc.
Hello, Michelle.
Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, B-A-I-L-E-Y.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay. And do you know what percentage of lawyers in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a board Supreme Court certified mediator, and that.
Zellman, was that a little dig at Everett there? Judges also get the peer review? Were you throwing a little dig at Judge Everett, Zellman?
Was probably the mid-aughts, 2006, 8, I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education. It might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review, and the enhanced.
I have another one for you there, Missy. Best lying lawyer Crime and Coffee elects you as Bitch of the Year. I can send you a certificate so you can hang it on your wall. I may do that. I may make Crime and Coffee certificates and send it to all these lawyers so they can frame it and put them on their wall. Wouldn't that be hilarious?
At the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir the witness as to their training or experience.
No, Your Honor.
In objection to her ability to provide an opinion in the fields of marital family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Oh, that means she gets a check from the Adelsons. She's been claimed an expert. Oh, I hope so. Georgia mopped the floor with her today. It was glorious.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson and Dan Markel in the 2014 timeframe. I was provided but didn't review thoroughly text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Okay. Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendy, where she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendy Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine, because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendy Adelson's request in that temporary parenting plan concerning timesharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay.
So when, oh, Jesus Christ. So she literally just said Wendy wanted 51-49 so she could get a tax break. She was using her children as a tax break. That was the most important thing for Wendy to get 51%, is because the children would be a tax break for her.
Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendy Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out on themselves, by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing?
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's some, the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendy Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent...
John, I bet you she's more excited about the trailer. The trailer in the land.
Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more.
Hey, tennis.
So, in other words, when Wendy initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, and then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then,
in other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, and I could be confusing this with a later motion, where the child care owner had made a recommendation about something, and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by a court or even put into any sort of formal document. So that was denied.
So he, let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just change their mind. So he was trying to enforce conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it, and he was basically saying that the petition for relocation was baseless and that the court should deny it, and the court said no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details.
Sorry guys, did you hear that? John sent me a couple songs to listen to, so I wasn't sure if you guys could hear it in the background. Sorry about that.
And just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances, plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically, or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get him, her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson Markel case, other than that June 21st, 2013 hearing,
I agree.
were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
I think I would get a copy strike on that. I think I truly would.
How many months elapsed between when the initial petition for dissolution of marriage was filed, and when the final judgment of dissolution was entered?
10 months.
How does that compare with Kate?
Let me see if I can pull John's song back up. Hold on, let me see. The one song John says, file not found. But
The jailer led her through the dorm, turned she'd done. Then a hardened woman walked over and looked her up and down. She said, "You must be the fancy lady that's got the word going round. We've heard you from Miami and that you're rich. From now on, fancy lady, you're gonna be my commissary bitch. You're in jail now, Donna, darling. You're not in Miami anymore. Say something wrong to the wrong woman, you'll pick your butt up off the floor. So be careful, Donna, darling. Before you speak, be sure you think. What you say could get you bitch slapped or even stabbed with a shame. Each night she lays her head down and her mind goes back many years to the decision she made long ago that destroyed
Oh, sorry.
lives.
Oh, Siri wants to play. Where did it happen? Oh, it went off on me.
Now she finally realized she had no right to do what she had done. No mother has the right to take the life of another mother's son. Now her daughter may be arrested, her son serving life without parole. It's her turn to face the music for living her life with a black soul. Soon she'll hear that one word that will bring her to her knees. When the jury stands and says guilty, she'll know she's never gonna leave. You're in jail now, Donna, darling. You'll never be free anymore. Say something wrong to the wrong woman, you'll pick your butt up off the floor. So be careful, Donna, darling. Before you speak, be sure you think. What you say could get you bitch slapped or even stabbed with a shame.
Sorry, guys. I had to. You know what? When Donna gets convicted, John, we should just be blasting that everywhere. Yeah, the life of another mother's son, that line hits hard. It truly does hit hard. I'll go back to this lady because I'm very interested in what's going to happen here.
Cases that have similar issues.
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial. And
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
no, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly.
Yes.
What?
Here in the
Did she see the binder? What is it, 900 and I think it's 936 pages. This divorce was not, she said it was amicable. Did she see the binder? I just have to know. Did she see the binder? We've all seen the binder. Oh my God. And you're right. Exactly, and that was another reason they wanted him out. Wendy had to be so jealous, Amy. Everything Wendy could never be. Yep.
The underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days, and then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is.
Yes, she is, Michelle.
Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendy Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, I believe Wendy, was she deposed?
I don't recall seeing that Wendy or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay, can I just point out that she calls Wendy by Wendy, but she calls Dan by Mr. Markel? Does she have a personal relationship with Wendy? Or is she being respectful
towards Dan.
Did you find anything unusual about my client Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings.
Who the hell's employer gets involved in their divorce? Their employer nurtures them? I bet you they've kissed on the lips too. No, she keeps calling Wendy by Wendy, very personal, and Dan by Mr. Markel. So I'm just wondering if there's a personal connection. Maybe this piece of work was one of the ladies Wendy was going to meet with that day for lunch.
There were lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Oh my God.
Now, in the
Oh, how thick can she put it on there? They're worried about their babies, no matter how old they are. Yeah. That's at least a trailer. That statement is at least a trailer.
emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And
I paused it, guys. And I'm counting to 10. Forwards and backwards. Excuse me, you 2-bit piece of shit. You did not find that rude? You did not find that disgusting? Appalling? What more? It's a word to describe somebody that talks gibberish. If I had a fucking mirror right now, you would be looking in it. Because you talk gibberish. How the hell does she sit up there? Oh. I gotta get her name. I'm calling her fucking office tomorrow. I'm calling her fucking office tomorrow. I'm going to call her office and I'm going to leave her the real meaning of the word gibbers. You know what? Everybody call her office and leave the real meaning of gibbers on her fucking answering machine. Guys, I'm trying to be good here. Trying to be good. Oh my God. So this is what Red was talking about. Oh, I'm calling her office tomorrow. I've called Jackie's office. I will call this bitch's office too. Hello, Officer Gray. How are you, friend? Oh. Oh, I'm glad that Georgia does, but I'm going to also. I'm going to probably have a little couple extra words that Georgia could not say to this 2-bit piece of shit lawyer.
If you look at Mr. Markel's motions and memorandums and responses he filed in this case.
Oh, I basically told Jackie she's a piece of shit and that she does not have the right to call Danny Danny. She needs to show him more respect. She is defending the person that murdered the man. She should, and I expect her to, address him as Mr. Markel, Daniel, or even if she wants Professor Markel. I don't care how, but she should not be calling him Danny. It's disrespectful. And I left that on her answer machine. You are my female counterpart. Oh, I'm telling you. How does... Okay, we're going to move on. I will deal with this tomorrow.
It was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking
Hey, lady, you're talking gibberish.
enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting.
Officer Gray, that's exactly what I said. This bitch has been an expert witness. She's getting paid by the Adelsons. Oh my God.
Drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph, that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014,
oh my God, you know what? I want to know if Stephen Webster is watching this. Oh, he's gonna lose his shit. Oh.
what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion the end of October. Then there was no response, nothing. His lawyer.
I honestly, Red, I think this woman is completely jealous of Dan Markel because he was a brilliant man. And she is a 2-bit gumball dispensing effing lawyer. Oh. Dan Markel, God rest his soul, laying in his resting place, is still smarter than this bitch. Is still smarter than her. Rochelle, of course, Stephen Webster's watching every second of this trial. Oh my God. Yeah. I would say she probably doesn't represent men. Oh.
Withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you reviewed, appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw between them.
Certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Hey, Zelman, ask her what she thinks about Donna saying, I'll dress the kids up in Nazi uniforms. Ask her that. I want to know what she thinks of that email. Do you have the balls, sir? I don't think you do. I, myself, have bigger balls than you do, Zelman.
You are representing clients. How do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want...
Jane, I like Carl Steinbach on take on the Adelsons, but I love Crime and Coffee Crew because we get to cuss here and make fun of people. Could you imagine if I was like, nobody cusses, nobody says what's on their mind in chat? I can't do that. I can't practice what I would be preaching. So, no, this channel was set up so people could all come together and exactly blow off steam. Say what you're actually thinking about these trials. The other channels are meant for, no caps, no nothing, no, no. I'm human. I'm gonna cuss. That's just the way it is. And if I want to call somebody a bitch, I'm gonna call them a bitch. You heard me earlier call Zalman a prick. I'm gonna do it. People don't like my language. That's okay. There's other channels. There's no rules here. Just be yourselves. Say what you feel you need to say. LJ says this is why we love Rochelle. Yeah. I'm not, no. We sit and we watch these trials. And before I started this channel, I was screaming at my TV. And I would go into chat rooms and everybody was like wearing their Sunday best. And I'm like, okay, I don't fit in here. I don't fit in because I want to say, did you see that fucking bitch? And I can't say it, so this is why this channel got started.
Educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved.
Oh, absolutely. I have nothing against Carl whatsoever. The man hasn't been wrong yet in this trial. He hasn't in all of them. I have nothing. I just don't go in chat. I will go in, I will say hello all, and then I close the chat right off because I know myself. My fingers will start cursing. So I don't want to get kicked out of Carl's lives.
It's helpful to have them there so they learn as you learn, and they understand how you reach an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is.
Oh, that was a nice, aren't you clever, Miss Little Goldie fucking Locks? Isn't that a nice way of saying to the jury, everybody believes me. Everybody believes me. I say to them, if you don't trust me, then you go somewhere else. And they don't. Because they trust me. That was a backhanded way of saying to the jury, everybody trusts me. I'm so good. You should trust me. Because everybody does.
Is valid or is going to help you, and we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails.
Exactly. Please, somebody ask her that question. You're here as an expert witness about the divorce. But why did the defense team not want the divorce stuff to even come in? Yeah, I know. I know that's why my channel's still small, because I have an issue. Tennis girl, I have an issue. When I get irritated and I get mad, I bring in all my past lives, such as sailor, trucker. You know, they just come pouring out of me.
That Wendy was sent by her mother. Did you see evidence that Wendy shared those with Kristen Adamson?
I saw no evidence that Wendy shared them.
And did you speak with Miss Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Miss Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her.
I tell you what, chat. Tennis has got a point. You've all done it. I've seen people put BS. I've seen people put F star blah blah blah. I promise you, if you feel like you've got to put that in chat, I bring it up on the screen. I will say exactly what you're trying to say.
All the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for, and that was to last 3 years, and then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, you know, the division of child care, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision making, which is extremely difficult to do. The only time a parent gets sole decision making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision making that he requested. He also requested for more than 50% of the marital assets because he said he earned more and he...
Okay, lady, shut the fuck up. He didn't ask you those questions. Do you the ending of this, Rochelle, or no? No, I don't know. I haven't seen any of it, Dawn. I was at work today. I didn't even listen.
Created the assets more than she did, which is not a valid legal position, and she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Yes, she was. Yes, she was. There was Skype calls. Yes, she was. Red and white, she sure did, and Rochelle is going to love it. I hope this part isn't too much longer.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't.
Tennis girl, so you don't think Donna's going to testify? I just hope defense doesn't drag out everything tomorrow. If jury gets it by 2 p.m., I predict a verdict same day. So you're thinking Donna won't testify? Oh no, I want her to testify.
And say you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see the parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
Now, later...
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement. So
from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just 3 months later, the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So, Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she
Correct.
waited to file.
She did. And even that was a pretty ordinary.
Okay, chat, I need your help. Did anybody catch this bitch's name? Her full name?
Motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment.
Again. Did she not see the binder? We all seen the damn binder. Okay, thank you. I couldn't remember her last name. I'm looking up her phone number right now.
She can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails from between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation would be dismissed, so.
Oh, I got her phone number. I thought maybe the coffee crew would like to hear. I'm going to call and leave a message now, because I can't let this go. I won't be able to sleep tonight.
Your call cannot be completed as dialed.
Oh, her number don't work. Her number don't work. Your number cannot be completed as dialed. Did she shut her phone off after that? No. It literally says your number cannot be completed as dialed. I have a United States plan. So, oh, you clever little bitch. Okay, hold on. Is there another way to contact her? Nope. Her website is even saying can't reach this page. I'm going to show you guys. Oh, no, I can't show you because it's her phone number. YouTube will get mad. Linda A. Bailey. Wait, hold on. Let's do this. Oh, she shut her website down too. Holy crap. I can show you this. I can show you this. Oh. Oh. I can show you this, that's for sure. Your access to the site has been limited by the site owner. If you think you've been blocked in error, contact the owner of the site assistance. Oh, and her phone number is shut. No, sir. Oh, you cowardice little bitch. Mm-mm-mm. What a little coward. Oh. She's got to turn it back on sometime. I'll try constantly. I don't give up. When I've got something in my noggin, I don't give up. She put herself, as Bob said, it's the Russians. Yeah. Oh my God, I can't believe that.
Now,
Hey,
prior
Victoria.
to final judgment being entered,
No, Dawn, because I have a United States-Mexico plan. So I should be able to. That's freaking hilarious. Oh my God.
would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediation,
Good night,
it's
glass
often
half
common
full.
to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
Routine.
that. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it's a few month period, even after these motions
Hello.
had been filed, that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief did include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness? We'll approach with courts 1, states demonstrative A, specifically page 338. that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which
Okay, so I found another number. I'm gonna try it right now. Oh, one, it's ringing.
The law office of Linda Bailey. Our office is open Monday through Thursday from 9 a.m. to 5 p.m. and Friday from 9 a.m. to noon. I'm sorry we've missed your call. Please leave a detailed message with your name and phone number, and we will return your call as soon as possible. Thank you.
Hi, yes, Linda Bailey. I saw your performance today at the Adelson trial, Donna Adelson's trial. You, ma'am, should be absolutely ashamed of yourself. I'm just wondering, and I'm very curious, how much it cost the Adelsons for you to sit on that stand and lie like you did. There's a word we call people like you, and that is a lying bitch. And you deserve to rot in hell for what you did today. And gibbers is not about somebody that's gibberish. Gibbers is ignorant, rude, crude, and, you, ma'am, were gibberish. I just thought I'd let you know how I thought of you. And I think you are a lying, two-bit piece of shit. You have a wonderful day. There. She'll get that in the morning. I did tell her to have a wonderful day.
does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer the...
Patricia, I'm sorry, guys. I am absolutely sorry. But I needed to tell her what I was thinking. I can't just hold that in. You guys know what I'm thinking. She needed to know what I was thinking. And that's it. She's a lying two-bit piece of shit.
To the former wife, the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same. Order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
On LinkedIn? Oh, I will. Oh, I will. Hey, lady. That's the binder we're talking about. I'd probably get in trouble for the words that I really wanted to use, John. She's worried about Georgia. Go, Georgia, go.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Miss Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendy Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that Grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendy in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendy to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion.
Oh, Red, you missed it then. I just called Miss Linda and left a message for her, she can get it in the morning.
You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendy had these other financial violations. And then she referred to the Schwab account that you've heard about, and a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendy. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of
I cannot find her reviews. Can someone tell me where to find them?
financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendy Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that. to know what the then value was, but those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another.
How long does he
Something like
keep
that.
her
It
on here
wasn't
for?
Legally supportable. Anyway.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Okay. Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule.
It was 84 years.
It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud.
Okay, hold on.
So if you find out later that they had won the lottery before you and didn't disclose, or that one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made, well into this very long motion, was he brought up the stupid allegation from November, and this is the end of March. So I didn't see anything in his allegations that had any recent problems with him being
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar.
Okay, can I just say, Zelman, the lady sitting beside Jackie, that's who you're supposed to be defending. You're spending way too much time on this divorce. Way too much. Way too much time on this divorce.
This are these 10 volumes a example of a hotly contested relocation case?
Well, and I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so perhaps
Yeah,
only
it was
one
a
of those
happy
volumes
divorce.
got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
This is Dallas, but
Oh, look. She's got a Daryl Brooks castle. She's got a Daryl Brooks castle. Oh, this is brilliant. This is not Dan's files. Yeah, no. I love that they gave her a Daryl Brooks castle. A little fort.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
it's a stay.
Judge, may we approach?
Oh my God.
Judge, we're entitled to make a record. I believe I have...
Speaking.
Members of the jury, the bailiff will take.
Speaking objection. Stop it.
You to the jury, then.
You know what the jury's thinking right now? The jury's thinking, thank you, Georgia. Thank you so much.
You may be seated. The relocation issues within this case are certainly relevant. As to a separate other case, what is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witness has identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Woody Adelson and Mr. Dan Markel.
Woody Adelson?
Kappelman, any other argument on this issue?
It's relevant, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce files certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Ms. Bailey, please step down, step out of the court or the courtroom doors. If you can radio Deputy Bump to leave the jurors in the room, please approach.
Judge Everett's about to scream, this TV costs $5. Judge Everett, he's going to say, by any chance, has Luis Rivera been sent back yet? I have a trip I need him to take. And tell him this TV costs $5. Oh my God. Yeah, I call them chesticles. Oh. Yep. Yeah, George is not happy. I don't think I've ever seen George's face that red. Bruce like, I need to go. I need to get out. She was told to leave the courtroom. Oh my God, she was told to leave the courtroom. She wasn't going to leave the courtroom.
I'm going to remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom. Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
Unbelievable. He told her, leave the stand and go outside the doors. He told her. Oh my God. She doesn't want her eyes to be seen. Holy crap. She's gonna fall over. She's gonna fall over.
All right, they're entering the courtroom.
Oh, thanks, Leah. I feel better now.
Everyone can be seated. Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable.
What? Simple routine? What? Oh my God.
I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full-day
I've seen that, yep.
deposition of just one party. This was an easy case compared to many.
Bloody hell. Oh my God, what kind of drugs is this woman on? Easy case. Easy case. Holy. That Adelson cash must be scratch and sniff, let me tell ya. It must be scratch and sniff Benjamins.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-examine.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you
Well, that's
agree
one
with
reason-
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm, and I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers.
Oh, shit. Oh my God. She put a dig in at Everett in the beginning about judges having to go through peer reviews also. If that wasn't a dig at Georgia, you know, like some lawyers where they have to stir things up. Oh my God.
Lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to ID.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
Well, I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people that whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was litigated. It was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feel.
No! No, she didn't just go like that. Not for me, but I didn't grow up in Iran or. Oh my God, now I gotta call her and call her a racist bitch on top. I forgot. I didn't know. You guys didn't tell me that she was a racist bitch. Iran or whatever. Oh my God, she didn't.
Exactly, Ms. Bailey. To that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't
Exactly.
It shouldn't have been. There was no proof.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think.
Oh my God, guys. Oh my God.
On that issue, he clearly had the asset, so at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay. Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And Ms. Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms. Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's no question you strike.
I'll rephrase it.
What is the objection again?
What was the objection again?
Witness's testimony.
Stay, please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get you know, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays and he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay, because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. That doesn't, there's no jail consequence to the $70,000 to Wendy. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall saying that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were... you weren't provided any?
Oh, Donna didn't like that line. What do you mean you weren't provided?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right, and if he was murdered, it could happen, right?
Well, obviously.
Oh my God. I think I got smoke coming out my ears.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful.
Bingo. This right here. The thing is, Wendy gave up the fight of relocation because she had decided at that moment to take her bro up on his offer of a hitman. Right there. Mm-hmm.
It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that
Me
the
too.
things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well,
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
if there wasn't a party, the case would have ended, if that's...
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adelson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud, so she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time...
Yeah, but Tennis Girl in Florida, if she's guilty of either of the other two, then she's guilty of murder, right? In Florida, that's how it goes. Oh, man. She's got to be guilty.
Time of Dan Markel's murder, litigation was still ongoing in this case.
Yeah.
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled, the witness is providing an opinion, the state
Well,
will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's.
And unfortunately, we can't stop your nonsense bullshit on the stand.
Attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off. So
But that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly,
Because he was murdered.
clearly.
May I have a moment to confer, Josh?
What?
Wow. And we don't care in here about how many people are watching. We don't care. We're a crew. We watch together. We... Yeah, right, Auntie? Who's laughing now? Come on, Georgia. You got another one in you. Come on. Oh, no.
Examination.
Briefly, Your Honor. Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
Wow. I did get some lovely screen grabs of Georgia. She kissed Harvey? No, she did not. No, she did not. Did I go back far enough, Victoria?
Everyone can be seated.
Obviously not.
At 2:15. Enjoy your break. Everyone can be seated. Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
Judge,
Okay.
I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioned the gallery again. I don't know what steps the court needs to take in order for that to stop, but
the state, is this guy fucking for real? Is this guy fucking for real? He just let two witnesses sit in the gallery watching testimony. Is he fucking for real?
the fact remains that they're doing this in front of the jury could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is this coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Desclazo, I believe, is still to be called by the defense.
Yes, sir.
Oh, hey crew, can't watch tonight. My daughter's having a baby, so we are on baby watch. Blessings to all just as soon for the Markels. Congratulations. Congratulations. I gotta find this. I gotta find this. I didn't see her walk out. I gotta see this, her walking out.
Redirect examination.
Briefly, Your Honor. Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial.
No, she didn't kiss Harvey. That wasn't a kiss to Harvey. She bent over and she probably said something to Zellman. That was too close to be Harvey. Yeah, that was Zellman. Oh, sorry. I'll go back a second. That was Zellman. She was nowhere. She didn't walk that far. Because she come here, she bent over and said something to Zellman. Because look how much further she would have had to walk for it to be Harvey. No, that was Zellman.
Everyone can be seated.
Okay, hold on. Gotta go back a little. Now I gotta find it again. No, she just... I'm gonna get back to where she was on this.
20, please, with outside or any other person.
See?
Do not review or seek out any information outside from this court.
That was Zellman.
Doing something that was intended to distract the jury. That's clear.
Could happen in need caution.
Wow, did it ever jump far?
Any discussion, everyone can be 15. Enjoy your break. Please report by 2:15. And today, we will resume litigation outside from this courtroom. Do not review or seek out any information outside from.
Did it ever skip forward?
We will resume with the trial this afternoon.
Yeah,
today
no.
At 2:20.
Yeah, that was Zellman. She didn't walk far enough. I don't think Summer Sunshine, she didn't kiss him. I would not say she kissed him. I would say she leaned over and said something to him. But it was definitely not Harvey. She didn't walk far enough. Harvey's further back in the gallery. Like if I go to here and pause it, she didn't walk. She would have had to walk quite a ways. Night, Dawn. To get anywhere near Harvey. She stopped and said something to Zellman. No, she didn't kiss anybody. That wasn't a kiss, that's for sure. Zellman sitting there whining. Somebody, and he's hearing, and I love how he said, "I hear it over my right shoulder." Well, it could actually be Harvey. There, Zellman, you might want to be careful. You don't get Harvey kicked out of the courtroom. Yeah, he heard Harvey farting. Yes, he does. He needs silver bracelets. Never prepay your addicted lawyer.
All right, 2 matters to briefly address before we bring the jurors on. The first concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Mr. Scalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf. Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do.
What is that scope?
The information that we discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
Get it in writing.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon.
Oh, she is higher than a kite. Jackie is higher than a kite. People can say, oh no, how would you know? How would you know? Listen, my ex was an addict. Secret addict. And I learned to see the signs of what he would do with his face and his eyes and everything. And I would know when he was on something. And she just made some of those. She is on. I would be okay with saying that Miss Fulford likes the snow. Just saying. Yep, she likes the snow. And yes, Officer Gray, I would love a Judge Everett teddy bear too. Yep, she is totally out of it. The way her eyes are, she's not looking straight on. She's like, her eyes are up on an angle. She just did the whole rubbing her gums with her tongue. Oh, she's higher than a kite.
You did not speak with your client concerning whether she wished to testify?
Absolutely.
The evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford.
Hey, Jackie. Hey, Jackie. Who dressed you this morning? You're so high. that you did not realize that you got a white earring and a gold earring. You're so high that you didn't even realize it. Oh, Lord, Jackie. Oh, my God. She's so high. She does know, like, this is going international, right? This isn't. Yeah, it looks like her shirt is buttoned with the wrong button. She's got a white earring and a gold earring. Look at her eyes. Oh, she's higher than a kite.
Concerning that has been.
Oh, there she goes. Oh, there she goes again. Did you catch it? She just did the gum rub with her tongue. Watch it. She just did it again.
Make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by
See
the
it?
court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided.
See it? Oh, Jackie. You likes the snow. Dave Lowe says $2 million for a stone lawyer. Good for you, Don and Harvey. Yep. Oh.
Provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial prepared for this moment. There's been time during trial, and specifically we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. Right.
Okay, I'm just going to clear this up. She did not bend down and talk to Harvey, touch Harvey in any form. She bent down as she got to Zellman. There was no way from the moment she got off that stand to the point where she did it, she was not nowheres close to Harvey.
I'll give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily.
No, Leah, I showed how far Harvey was from where she bent down. She bent over, yes, that's not a disagreement. She bent over, she was at Zellman. She was nowheres near Harvey. She was nowheres near Harvey when she bent down. She probably bent down, said something to Zellman, and walked out. But she was right at the defense table. Harvey's not right at the defense table. So he's gonna make. So you guys should know if she's gonna testify. He said they were gonna make her do it in 5 minutes. Oh, Donna's at sidebar. Okay, all right, crew. Are you pulling a nasty on me? Do you guys know? Do you guys know if she's going to testify and you're just not telling me? How dare. How dare. I'm just joking. You know I am. Unbelievable, crew. Unbelievable. I'm shocked you guys kept this secret for so long. Jane's in here. Jane, how did you keep that a secret, my friend? You always give spoilers. But we really don't know. Jane always throws out spoilers. Okay, nobody really knows. Okay. Okay, there's Judge Everett again. Oh, please tell me she's going to testify. Donna Adelson, I swear to God, I will haunt you when I go if you don't testify. Oh, then I wasn't paying attention. Oopsies. Oh no, she's not testifying, Tattles. Oh, that's disappointing.
Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you.
Oh, I'm so disappointed. I feel like a kid that woke up for Christmas morning and there was nothing under the tree. That's what I feel like right now. Oh, that's so heartbreaking.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that?
I say Donna didn't hire her because she couldn't say zap. All she kept saying was sap. Sap. And the gentleman even said ZAPP.
That caused you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia, and we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender?
Can I just correct her for a second? It's Mrs. Kappelman to you, ma'am. It's not Georgia, it's Mrs. Kappelman. Get it right. Another one of Dozy Donna's lawyers.
Surrender was something that could happen.
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions.
Sorry, yes. I said it backwards. He was saying SAP. I Googled it and I was correct. The doctor's last name was Dr. Sapp. And this clown repeatedly called him Dr. Zap. Yeah, I had it backwards. Thank you for correcting me, Michelle. I appreciate it.
About her traveling after the conviction, because around that time was when she was making a serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor. Nothing further, Your Honor?
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was before, definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Miss Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was...
Ray, what ocean would you be screaming at? Pacific or Atlantic?
Being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you.
Okay, friend. Here, there's gonna, when his trial's done, because I also would be screaming at the Atlantic. So, we'll pick a time and a day, and we'll both go to the Atlantic at the exact same time, and we'll both scream at the exact same time. I'm all for that. I'm in Nova Scotia, not too far away.
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going,
Okay.
and it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness
Well, then you would have been Canadian like me.
was opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight,
As her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
Bloody hell. I envy you, Rochelle. Saw a lobster roll today for $45. Bloody hell. Oh, that's right, Patricia. You can yell from the other side of the Atlantic. Let's go.
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second.
Well, I know they ain't getting my tourist money. That's for sure. And Patricia, the next time I go to London, I'm going to Liverpool. Or going to England, I'm going to Liverpool. Haven't been there yet.
Specifically though about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard. So I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, the prosecutor asked you about fleeing the jurisdiction.
Oh.
My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
How is going to Vietnam, even if it's on holiday, not leaving the jurisdiction? Somebody needs to get her a map. I'm just saying.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight.
You know what, John? I'll look into that. Figure out how to do it.
This evening.
You are released. Please call your next witness.
Just a moment. I'd like to recall Sarah Newhouse.
Look at oh my God, Jackie, enough. Watch her. Sarah Newhouse.
Please come up to the witness stand. Raise your right hand down. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what did...
Oh, this is the girl that's supposed to look like Wendy's sister. Oh my God.
What does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
Your Honor, at this point in time, I move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, no objection.
A lot of qualifications.
Well, there's just...
Members of the jury, we're going to take a brief break. The bailiff will take it in the jury room.
It seems to me she's still under the Adelson Kool-Aid.
You can be seated. If anyone needs to stretch their legs or use the restroom, please do it now.
She looks like Greek Wendy. Unbelievable. She could say what she actually thought, that she was being manipulated.
It includes Wendy Adelson saying this is the worst day of my life before the call connects. And then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't intend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
And as I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can go back to the jurors.
What did she just say there? Yeah, you just have to tell me when it was. We'll go back. I'll make sure we go back before we... It wasn't a drug handoff, though. I know what you're talking about. I just can't remember where it is. She grabbed her believe it was something like her phone or something. She grabbed it from the one girl at the desk. Trust me, there's no drugs in there right now, except for probably Jackie's purse in somewhere. But that would not happen in the courtroom, guys.
Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know?
Correct.
Do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the record.
Please sit down. As to the hearsay, sustained.
No further questions.
Redirect.
Hang on, we'll just strike the question from Ms. Kappelman.
Members of the jury, you are to disregard the last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
As to your exhibit, do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break. They'll take it to the jury room.
Holy Jesus. Break after break after break.
Everyone can be seated. Please make all necessary redactions and changes at this time.
We remember how we made fun of Rashbaum where he'd say, "Can we go to sidebar? Can we go to sidebar?" Oh my God. I wish. Oh, Rashy, why couldn't you have gotten the damn thing?
I cannot make you testify. Your attorneys can testify. Defendant have rights.
How did I miss this?
Do you need to or put on any rebuttal? But once the no narration.
That's right.
How did I miss all this?
If there are no other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation. I'm sorry.
I am capable of seeing that, Mr. Zellman. No narration is needed.
Come on, Donna, don't let us down.
Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they rest
What?
without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise.
No rebuttal?
Been placed on your oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
Are you effing kidding me right now? Are you kidding? And no rebuttal? What the fuck did they pay Charlie to come all the way this way for? No rebuttal. What about Stephen Webster? Oh my God, I don't like the odds now. No rebuttal. So Charlie Adelson gets a free trip to Florida, gets Wendy's. For what? He didn't do nothing. Oh God, now I'm stressed. That's right, he could have. Webster could have rebutted her. Webster's on the thing, on the witness list. Yeah, there is. Tanika 2 Cents has the video. Oh my God. So we don't. Yes, LJ. Webster would have made an excellent witness, especially with Fulford sitting there. Oh my God. So they could go to closings tomorrow. Put your answer in the form of a question. This is double jeopardy. Oh, she might feel more at home with... She might feel more at home with this one.
The extra time that you have been provided, that has come to a conclusion.
Everett, you cut me off, sir.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking before we have to move into any contempt.
I'm not talking for the sake of talking. Woo!
Move on. Mrs. Edison, the question remains, as it relates to your right to remain silent and your right to testify. What is your decision concerning these two rights?
This time I don't want to testify.
Oh, you slimy little bitch.
As I previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with the counsel?
Go ahead.
Come on. Okay, hold on here. Please, someone help me on this one, because for some reason my brain is not working. If they rest their case in front of the jury right now, she can't change her mind. Their case is rested. They can't come back in and say, oh, we changed our mind. But at this time, I don't want to testify. She can change her mind tomorrow. It's her constitutional right to get up on and speak. So if she changes her mind, they have to let her, right? But that's what I'm saying, Michelle. If they rest their case, okay, okay. Thank you. She still can change her mind until closing arguments. Okay, there seems to be many disagreements in chat about this. I would assume if she rests her case and Georgia does her rebuttal, that's it. Oh, I'm interested to find out that information. Let's Google this. Okay, hold on. So here it says, no, a defendant generally cannot change their mind and testify after the defense has rested its case. The decision to testify is a significant tactical one. And once the defense rests, the decision becomes part of the record. Allowing a defendant to change their mind after arresting the defense is often considered an abuse of discretion by the judge. By the judge, as it can disrupt the trial's proceedings and jury's expectations. Judge discretion. So it would be up to Judge Everett. If, oh my God. So it's not any, you gotta go on to the jail portal. So you go on to the jail portal, which is Wakala now. Because she wouldn't have, I don't know if she'd be bounced over to Leon County. Or does she get taken back to Wakala every night? She might get taken back to Wakala every night. But anyway, her jail mail is through Wakala jail now. So you have to go onto their site. You got to put her name in. And it's easy. She's the only Donna Adelson anyway. You put her name in. Then you have to buy stamps to write. It costs you one stamp for every time you write. She won't answer you if you don't send her a stamp to reply. Yeah, well, Georgia wants her to testify. Oh, come on. I did not see her not testifying. That was not on my bingo card. Nope.
There is one matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors. Or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing that needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. We'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, the counsel have a moment to confer concerning whether or not we are going to rest at this point.
Do you have another witness to call?
That's what we need to discuss, Your Honor.
Oh my God. Through the tablet. Oh my God. I cannot believe she's not testifying. Oh.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
How do they not know if there's another witness? Problem is, guys, here's the problem. She wouldn't get it till after the verdict. Every time you write, it takes at least 4 to 5 days to clear before she even gets it. Because it's got to go through their system. They read it, and then they release it to her. Also, Donna is a little late to think about the rest of your life now. Should have thought about that when you helped Charlie and Dan's, right? Yeah, Judge Everett is sick of their shit. And listen, Judge Everett, just remember the red velvet cupcakes that you got previously. Because unfortunately, I can't buy them this time around, because I can't find a Canadian company to send them to you. Or I would, sir. I truly would, but I can only buy Canadian right now. They're going to try and get permission to recall someone they claim is on their list who isn't. Oh my God. Cupcake tariffs. No, it's just, there's no tariffs on cupcakes. It's just that I have to buy Canadian. And the cupcakes is an American company. Oh my God. I can't believe she's not going to testify. Oh. Oh yeah, the cupcakes we got them last time came from a bakery just around the corner. They delivered in them and everything. I hope Georgia's closing is amazing. Oh my God. Poor Ruth. Oh, I feel so let down. Wow, I did not have that on my bingo card. I thought there's no way this woman's not going to want to tell her story. Oh. Everett has a food test run.
Is there another witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualify under hearsay exceptions. The state's indicated that they're objecting. If I could just have a moment.
You just had 5 moments. Night, Officer Gray. Take care. My male counterpart. Oh my God. Seriously? No, sir. This is no, sir. Yeah, did you hear Judge Everett sigh there? I unbelievable. And no rebuttal. No Charlie Adelson.
Gentlemen, concerning the items, we do need to move on so a ruling can be made.
This is the worst. Yeah, no. The one day you came in, you said something. Oh, what day was it? I think it was day 2. No, maybe day 1. And it was the first thing you said in chat, so that's why I said Jane always gives me the spoiler alerts.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar. That is, I believe it's states 51. No.
Oh, I've never seen people so disorganized. Rashbaum had better organization.
Gentlemen, concerning these items, was the state's argument?
State's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents, and the state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. based on the questions that were asked.
Yep.
The implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023, where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes
Who was going to lay the foundation concerning
Founda-
the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was
I
seized by...
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted. Not that she was...
Hold on. These are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation?
Well said, Patricia.
That are separate from the inculpatory information.
Well said.
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. These are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue in closing. It's the same argument as the 2014 calendar.
Just one.
Hey, Zelman, you know how you can get that in, my friend? Get Donna to testify. She can speak of it. She wrote it. Just tell your defendant she needs to testify to get that evidence in. Simple. Just saying. And I'm not a lawyer, and I understand that.
Excuse me, Your Honor. The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of...
Should this not have been done before the trial's basically done? Why is he arguing evidence now?
Offering the 2014 materials. It has to do with planning the 70th birthday party of our client's husband, and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you had already made?
The only entry from the 14 planner that was admitted, that has been admitted so far in this trial, is the page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate number, so I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as being seized from the residence.
Was there a ruling as the 2014 planner as well? Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor, and for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please begin the jurors.
And Judge, the state has made I want to check the redactions on this video.
Oh, I'm so
I believe this is just being admitted without being published, correct?
That's correct.
I'm so disappointed.
Jurors are fine to come in.
Ugh. Oh, what a letdown.
All right, you're entering the courtroom.
Paul says, get over it. I don't want to get over it.
Everyone can be seated.
Oh, very good.
Defense may call its next witness.
Daughter had a baby boy. Baby and mom healthy. Blessings to all. Oh, that's amazing. I'm so happy for your family. Congratulations. Oh, that's amazing. Do they have a name for the baby?
Yes.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
You're a coward, Donna. Yep. We've had a bouncing baby boy
Everyone
tonight.
seated. Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any?
Oh my gosh, I'm so mad. So, lady at work, I'm not going to complain because she's going through a hell of a lot right now. Her husband was just put in ICU this evening. So, she called me and said, could you please cover my shift? So I said yes. So I'm working tomorrow. Oh no. I work till 4 o'clock my time. So that would mean 3 o'clock Eastern. Oh my God, Dave. Oh my God. Thanks. Also, I won't kill to have custody of my grandsons. They can got home with their parents. Oh, yeah, they're just going to talk about the jury. What they say, instructions. Don't you... No, so I'm thinking I work till 4, so that's 3 o'clock Eastern. Oh my God. Donna, put a kink in my plans. Yep, the instructions, jury instructions. Could be a verdict. So I'm trying to remember. It didn't take Georgia, and I know that Rashbaum seemed long, but oh, Julia, I want her to change her mind so bad. Okay, here's what I'm going to ask you. You think it's going to be like that, John? You think it's going to be quick? If Donna would have testified, I would have thought it would have been a quick verdict. Now that she didn't testify, I'm sticking with 6 hours. Oh, of course. Yeah. Bye, Paul. Okay. Here's the thing. Thank you, Patricia. I always miss the afternoons because I work 1 to 4. I should be here. I try to catch most of it, but my kiddo I work with likes to hear music. I thought about Donna saying Charlie was nearly dead to her friends after his conversation. What a weird thing to say. Yeah. Rashi gave them Donna's planner. Yep. Okay, so bloody hell. They're trying to get a part of the planner in for the jury. Auntie Ray says, no, tomorrow will be a long day, 2 hours each for closing, and state get a rebuttal closing. But did they, I don't think they took 2 hours each for Charlie. I'm gonna have to go back and look. At least we won't have to hear puzzle pieces. But I guess I would rather hear Rashi, though. Oh, I'm so nervous I'm going to miss the verdict. Yeah, but I want her for murder. I want her for it all. Yeah, we don't know what to expect because they don't have a theme, a thread, or a story, right? Defense asked for 2 hours. They will take 2 hours, that's for sure. Urshel closing arguments will take half of the day, but I bet there will be a verdict before day's end tomorrow. Oh, guaranteed. Oh, you thought so? James says George is smart, won't bludgeon jury with excess verbiage in closing argument. She knows their nerves are frayed. Exactly, James. That's what I'm... Oh, that's a wonderful name. That's a wonderful name. That was my grandfather's name. Welcome to the world, baby Michael. They won't deliberate until at least noon. Yeah, because they came back at 2. It was 2 something in the afternoon for Charlie. And they'll get lunch. There was a murder in movie theater Casa in Florida. The jury came back at like 10 p.m. and it was live streaming. No, they're working on the jury instructions. That's what this is.
Request or changes being sought.
That they were working on the jury instructions. Okay, listen. I'm okay with, I'll review the closings when I get home. But I'll tell you this, friends. I will be home 3 o'clock Eastern time. and I will have a live going. I will go on, and if there isn't a verdict yet, we will go on verdict watch. Oh. Yeah, they're doing it right. I don't know if they finished it, Michelle, or not. I would assume Everett would make sure it was done. Oh, yeah, that was another good hour, so. Yeah, 4 maybe by 5 Eastern. Oh my goodness. I'm going to be at work. The defense never put on a defense. No, I agree they didn't, but is there anybody on that jury that's going to see her as the grandmother that said some bad things and her son took advantage of it? The judge will have to read the charges and instruct the jury also. The alternates will have to be chosen as well. Believe that took like 30 minutes. But then again, when they first come in, you know, Zellner and, or oh my God, I can't even speak. Zellman and Fuller, I'm putting the names both together, are going to have something to say. But Julia, if they only get 20 years for Donna, they're not going after Wendy. I think they have to get everything to go after Wendy. That's just my opinion. Rochelle says, no, Rochelle. No. Have faith in George's closing argument. She'll be great. Once she's finished, there's no way that they will not find her guilty. Just call me Zells. I think they will get life without parole, maybe only 2 out of the 3. Yeah, Laurel and Hardy. Oh my goodness, I feel sick to my belly. This trial was a long time coming, and it feels like it was too short. And it feels like Dave says 1.5 hour closing, 0.5 rebuttal, so half hour rebuttal. Dave, you think 1.5 for each, for the defense and the state? Julia says good chance Donna testifies though. Yeah, I didn't see that one coming. Yes, so do I, Michelle. It's been fun hanging out with you. As always, I'll say some prayers before bed tonight that Donna gets found guilty. I'm just sad I'm going to miss everything tomorrow. Oh, I'm actually going to try to find out how to leave work early. I'm working on that in my noggin right now. I really thought they would not go. I thought tomorrow they would have closings, but I didn't think the closings were going to start till the afternoon. So I took Thursday and Friday off. Oh boy. All right, everyone. Well, thank you for joining me. I appreciate every single one of you. Please send out your prayers tonight for Ruth and Phil and Shelley. They truly need it tonight. Send out prayers that Dan gets justice tomorrow. But for sure for Ruth, Phil, and Shelley. I feel sick to my stomach. I can't even put myself in their shoes. What they must be feeling right now. Oh. Hopefully one more Adelson down and another one to go. All right, everyone. Again, good night. Be kind to yourself. Be kind to others. Give someone a smile tomorrow. You never know what they're going through. See you tomorrow, everyone.